Every week, a lot happens in Parliament. Debates rage, bills are discussed, and laws are introduced. So it's easy to feel like you don't quite know what's going on in the chamber. So we're lifting the lid and telling you exactly what happened this week in Parliament. This week saw a debate on the issue of police informants and the use of child spies, as well as a proposal to disclose ministerial conflicts of interest when it comes to coronavirus contracts. On Wednesday, we saw the House of Commons vote on the Covert Human Intelligence Bill. In order to understand this story, we need to explain a very short bit of history. Put simply, covert human intelligence sources are informants. They work on behalf of an official agency and aid with investigations. Importantly, informants can be authorised to break laws when aiding with investigations. It's necessary for informants to be able to break some laws, or otherwise they wouldn't be able to get the access that's required from them. An example of this is infiltrating an illegal organisation. If an informant is bound by the laws of the land, they wouldn't even be able to join. This is obviously quite a simple and uncontroversial example, but it gets a lot more complicated when you try and draw the line of what is and isn't allowed, and that's what the government's been struggling to do this week. The bill is attempting to essentially go through and clear up the law on what agencies are allowed to use sources for. Previously, some agencies have relied on a secret code of conduct, and others on pieces of legislation. Essentially, the bill aims to lay out what is and isn't allowed in relation to informants. The issue the government's having is that the bill hasn't cleared it up as much as some would have hoped. The legislation does not actually draw a line on what laws informants can and cannot break, leading some prominent skeptics to question what the limit actually is when it comes to informants. However, the government minister charged with defending the bill has made the following statement on this.
I will start by saying that the limits on what could be authorised under the bill are actually provided by the requirement that any authorisation must be necessary and proportionate and must comply with the Human Rights Act. In creating a checklist, therefore, as Amendment 2 seeks to do on the face of the bill, we would make it very easy for criminal gangs and others to develop initiation tests. And it will certainly be the case that some criminals, Mr. Deputy Speaker, in seeking to demonstrate that they are not a covert human intelligence source, will go away and do what is asked of them, and perhaps even commit a rape or other serious offence in order to demonstrate their loyalty to the cause and prove, as it were, that they are not a covert source.
He also had this to say about the claim that the bill doesn't rule out child informants.
And no doubt it is motivated by a desire to protect young people. And Her Majesty's government also has that motivation. And let me start by saying that this bill does not seek to give public authorities new powers to authorise juveniles as covert human intelligence sources. What the bill does is simply create a clear and a consistent legal basis for the authorisation of a covert human intelligence source to participate in criminal conduct, where that is necessary and proportionate.
So clearly the government believes that the safeguards put in place and the fact that children will only be used in exceptional circumstances as informants is sufficient to protect them. However, some disagree, such as Labour's MP Stella Creasley.
To acknowledge that if we do not include Amendment 4 in this legislation, there is no other alternative provision to cover this scenario and the inconsistencies in the arguments they are making today. The Minister has said that there are no new powers in this legislation when it comes to child chises, but there are no protections either. And he'll be well aware that the government was taken to court by Just for Kids, where the court said that children were being put in harm as a result of these proposals. So this House does have to act. The government's own guidance accepts that participation in criminality is inescapable as a feature of being a chiz, including for children. And ministers have said that there is increasing scope for young people to be used as they are increasingly being involved in criminality. Bluntly, that as the criminals use more children, so should we. Now, the Children's Society estimates that there are 46,000 children involved in such gangs, 4,000 in London alone. The government is asking us to treat these often broken, scared and young people as capable of consenting to engage in criminal behaviour. Children we spend so much of our other time trying to get out of harm, the government is now trying to argue that in order for that to happen, we must put them directly in harm's way.
So after this debate, the amendments which aim to stop extreme crimes from being committed and place curbs and safeguards on the use of children were voted on. Ultimately though, they were voted down, with 363 MPs voting against and only 267 voting for, which means the bill progresses without these clarifications or safeguards. While we've tried to provide a brief overview of the bill here, it's a pretty complex thing, with lots of arguments on both sides. It'll be impossible for us to summarise the whole thing here, so if you're interested, you can take a look yourself. It's linked in the description. In the second story today, we're going to discuss what's known as a 10-minute rule motion. In effect, this allows backbench MPs to propose a bill to the House of Commons. If it's successful, it moves to a second reading. Usually though, when they come from backbench members of opposition parties, they're voted down or simply not allocated time, meaning that at the end of the parliamentary session, all progress is lost. It's important to note here the reason they're called 10-minute rule motions is because the MP only has 10 minutes to explain why other MPs should back the bill. If someone opposes, then they also have a maximum of 10 minutes to argue against the proposal. And then after that, the bill's voted on in the form of a voice vote, which is exactly what you'd expect it to be. So enough about parliamentary procedure. What actually is this bill? Well, I'll leave it to Owen Thompson, the bill's sponsor, to explain.
Thank you, Madam Deputy Speaker. Madam Deputy Speaker, I beg to move that leave be given to bring in a bill to require a minister to make an oral statement to Parliament if a contract is awarded under emergency statutory powers to a person in whom, or a company in which, a minister has a personal, political, or financial interest. Madam Deputy Speaker, today I present an important bill which would help safeguard against the risk of procurement corruption and restore some trust in the integrity of our democratic processes at a time when this trust has been rocked to the core. Anyone in public office should be there to serve the public good, not to exploit their position to line the pockets of themselves, their pals, or their party donors. Yet during this crisis, we've seen lucrative contracts go to firms with little experience in public procurement, but with very clear links to people in power. Issues with cronyism are not new, but there's been nothing of this scale before, nothing so blatantly disregarding due process. It could be said that a crony virus is threatening the health of our public services, and emergency action is needed to get the government under control. I fully understand there was a need to procure goods at a scale and speed never done before when the pandemic struck. So the usual processes to ensure best value to the public purse did have to be set aside. But to many, it looks suspiciously like the emergency has been used as a catch-all excuse by this government to bypass due process at every turn. The National Audit Office reported a staggering £10 billion worth of contracts have been awarded without competition by the end of July last year, and more than a few of them have raised eyebrows.
So that's what the bill aims to do, and as expected, it's progressed to the next stage.
Thank you, and I've had no indication that anybody intends to oppose this motion, so I will now put the question. The question is that the Honourable Member have leave to bring in the bill. As many as will have been say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. Who will prepare and bring in the bill?
As we said earlier on though, despite being voted through, it's unlikely the government will allow it to become law. After all, it would mean them voting to make themselves face Parliament when they sign a contract with a friend. Having said that, 2020 is already a year that's far from normal, so who knows really. If you want to be updated with what happens in Parliament next week, then be sure to subscribe to the channel. Or if you prefer to listen to the weekly update, then you can subscribe to the Daily Briefing podcast feed, where you'll find a daily summary of the week's news, and every Saturday, This Week in Parliament.